1, 2. Microphone check. How's my audio? Thank you. What's up, Bogey? Well, what is up, everybody? Hope everybody's having a good day. So, I went on, I guess, a little bit of a dive back into Ron Logan's affidavit. And I want to kind of basically show you that journey. Really started off with the Fourth Amendment, kind of understanding the penalties and what you are and what you're not allowed to do as far as affidavits. So we're going to talk a little bit about the difference between the ability to mislead, from what I understand, from what I can see in an interview, is much different than misleading in a probable cause affidavit. Now, it appears you can be biased, to the probable cause or to the person or to the direction you're trying to go, but you cannot mislead or even withhold information, from what I understand. And hopefully you guys can help me understand this better. But we will be taking a look at all that information. But before we do, let's see what's going on in the chat. Nadia, what is up? Taxca, good to see you. Hey, what's good, Zen? You guys see Caleb Plant over the weekend? It's a good knockout. Hey, Rebecca. Hey, Vanessa. Frank Meister, good to see you. Miss Thang. Reach into my soul. Hello. Oh, yeah, it was good. And then the way he picked up the shovel like that, was burying him. Oh, man. Legendary. Thanks, Miss Thang. Yeah, I was ready to come home. It was about time, kind of, after a while you miss your own bed and comfiness of the house. Bogey says makes the possible evidence inadmissible. Ron Logan affidavit was shady in my opinion. D agrees. Super shady. Sharon, what's going on? Good to see you. The lesbian historian. Hello. Good to see you as always. Hey, Psych. It's good, Chopper. Baby Bear. Hello. Ann Vroom, hello, says if a defense lawyer can prove a warrant was obtained based on false representation, then the evidence obtained via that warrant is excluded. Fruit of a poison tree. And that is correct. from what I can see, yes. I'm no expert. But from everything that I gathered so far, I would have to agree with that. Hey, Abby's grandmother. Pre-trial? I'm not exactly sure. I wonder if that's either the time they're going to make a deal or when he's going to say, I'm pleading guilty or not guilty, but it definitely comes way after being charged with the crime, and he hasn't been charged with anything in regards to Delphi anyway. We know he's got plenty to deal with the CSAM. Rhonda says, I don't think a 60-year-old could have the stamina or strength to commit that violent of a crime. The perp would have had to have it been in fairly good shape. Well, in this affidavit, they try to make it seem as if Ron Logan is very capable, even personally witnessing on some occasions that they've watched him, go to and from the crime scene with ease. Hey, Lisa, thank you. Good to see you. Yep, that's what I'm thinking. But I also have a feeling that they may have spent a little too much time and put too many eggs in the Ron Logan basket. And that could be a big part because of this affidavit here. And we'll talk about it. We're going to play a couple videos. We're going to talk about the Fourth Amendment. We're going to talk a little bit about some cases where law enforcement and FBI face some serious penalties for misleading to get search warrants. And some of these search warrants led to some pretty horrible events. So, and then we'll get to the moral of the story, and then we'll dive right in to the affidavit. I've highlighted some things, make it a little long-winded, but I'm sure you guys are okay with that. We can always, if we get bored with what's going on here with me, refer you to the chat. Hey, Lorraine. Jen from the suburbs, Folk Beach. Good to see you guys. Hope you're having a great Monday. Just poured me a cup of coffee. I'll let you know after that. I spent all morning reading about what you can and can't do when you are trying to petition a search warrant from a magistrate or a judge. Sykes says pretrials where both sides agree they have what they want before they proceed with the trial. It's like a meeting, talk about issues, it sounds like. Hey, Rebecca, that's good to hear. Hope you continue to heal, D. FBI has been overreaching and abusing power over the past 5 years. Yeah, Andrew, I'm very familiar with fruit of a poison tree. It's basically like anything that stems from your falsified or misleading information is no longer considered valid. And we're going to talk about that actually. There was a case where there was a police officer who had misled, and it led to about 30 cases being overturned. Only because they couldn't trust the information. Not that they could even verify it. It's just that it no longer was trustworthy. Yeah, that's good, Rain Dancer. I try to stay active. Hey, what's up, B Hart? Says the affidavit is clearly worded a lot of in the proximity when his house is 1,400 feet from the location the bodies. Isn't that in proximity? Yeah, and we're going to talk about that as well. I agree with that. Ironically, I think Curtis Fouts signed the warrant, and we will take a look at who signed it as well. Let's see. All right. So let's go ahead and get started. I guess I didn't really map this out, but I have a pretty good idea of like the direction I want to go, and from start to finish, I'm pretty sure how I want to present it. So let me start by sharing my screen here. Yep, that's exactly correct, Dan. Yeah, and honestly, it's not really up. Like if you're knowingly misleading an affidavit, yeah, you can get in trouble, but ultimately it's up to the judge, to determine if probable cause is within the document. So let's go ahead and everything depends on the Fourth Amendment, right? And the Fourth Amendment originally enforced the notion that each man's home is his castle, secure from unreasonable searches and seizures of property by the government. This is back in the days where men or people, men and women, knew that they were the government. They were the control. They voted for people to represent them. So it says here it protects against arbitrary arrest and is the basis of the law regarding search warrants, stop and frisk, safety inspection, wiretaps, and other forms of surveillance, as well as being central to many other criminal law topics and to privacy law. So the Fourth Amendment, as written in the Constitution, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So, I mean, it's pretty clear here. If you're trying to petition for a search warrant, the information that you're providing has to be, to the best of your knowledge, accurate. Okay, so I pulled some videos that were on some of the websites I was looking in that I thought might be helpful. It's always easier um, if they're going to go out of their way. And everything that I'm sharing with you guys today, the links are in the description because I may not share all of the information. So if you want to go back and follow up, just at the down in the description, you'll find everything there. All the links will be present. And they will be in order as well.
In the United States Constitution's Fourth Amendment, we're introduced to the concept of probable cause, as that amendment states that no warrants shall issue but upon probable cause. But what exactly does that mean? Unfortunately, the Constitution doesn't define it, and for much of our nation's history, judges, law enforcement, and lawyers have struggled to interpret the idea. In this presentation, we'll look into the development of probable cause, its purpose, and what law enforcement needs to do to establish probable cause for an arrest or search warrant. The Fourth Amendment guarantees the right to be free from unreasonable searches and seizures by the government. Also, before a search warrant can be issued, the government must demonstrate probable cause to believe a crime was committed and that the proposed search area contains the fruits of illegal activity. A probable cause determination balances the right to liberty with the government's interest in preventing and investigating crime. It gives law enforcement flexibility in enforcing the law and protects people from rash and unreasonable interferences with privacy and unfounded charges of crime. Mere suspicion on the part of the police is insufficient. Law enforcement can establish probable cause through live sworn testimony or by a detailed affidavit describing why a warrant is necessary. In 1925, the United States Supreme Court decided Carroll v. United States and provided the contours of probable cause. In that case, the defendants were convicted of violating the National Prohibition Act after police searched their vehicle and discovered that they were transporting 68 quarts of whiskey and gin. In determining that the search was supported by probable cause, the court wrote, quote, "Good faith is not enough to constitute probable cause. That faith must be grounded on facts within the knowledge of the law enforcement agent, which in the judgment of the court would make his faith reasonable." The court further expounded on Carroll's definition of probable cause in Brinegar v. United States, another case that dealt with illegal transportation of liquor. In finding that the police had probable cause to arrest the defendant, who had a reputation for hauling liquor, after they noticed that the vehicle was heavily loaded, the court reasoned, quote, "In dealing with probable cause, we deal with probabilities. These are not technical. These are factual and practical considerations of everyday life, on which reasonable and prudent men, not legal technicians, act." Thus, probable cause exists where the facts and circumstances, within the officer's knowledge, are sufficient to allow a reasonable person to reasonably believe that an offense has been or is being committed. The probable cause standard cannot be quantified into exact percentages because it deals with probabilities and depends on circumstances. The court has even stopped state courts from adding more precise quantifications of probable cause. Many search warrants are based on information provided by confidential informants. One study finding that between 80 and 92% of search warrant applications were based on anonymous tips. Courts analyze the totality of the circumstances to determine whether a tip is sufficient to establish probable cause. In Illinois v. Gates, the Bloomingdale, Illinois Police Department received an anonymous letter that a local couple had been selling illegal drugs and that had over $100,000 worth of drugs in their basement. The letter also described the couple's travels to Florida to procure illegal drugs and sell them in Chicago. A search warrant for their residence and automobile was then obtained from an Illinois judge based on the Bloomingdale police officer's affidavit setting forth the information in the anonymous letter. The Illinois State Supreme Court concluded that the anonymous tip could not justify probable cause, because the letter lacked important details and police weren't able to independently corroborate the letter's details. The Supreme Court, however, disagreed, holding that the magistrate who issued the warrant had a substantial basis to conclude that probable cause existed. Justice Rehnquist wrote for the court that analyzing probable cause under the totality of the circumstances is not rigid, but is fluid and flexible. Probable cause may be established even if a tip appears to be deficient. Anonymous accusations of illegal behavior may justify a search or seizure if police could corroborate some, even if not all, aspects of the anonymous informant's predictions of a suspect's illegal behavior. It appears that establishing probable cause.
See, I thought that part was interesting. They don't have to prove all, but some. It's almost like you can give them a whole list of stuff that you can't verify, but you have a strong feeling about it, or I'm pretty sure about this, but I'm not 100% on it. But as long as you include some facts in there where the judge can say, you know what, even though I'm not sure about pretty much the majority of this one piece right here is enough for me to say, there is probable cause.
Based on the totality of the circumstances favors law enforcement because it's so malleable. Police have a great deal of leeway to demonstrate probable cause because police have so many ways to show that the circumstances demonstrate probable cause. Still, police may not use an anonymous tip alone to demonstrate probable cause, because an anonymous tip alone seldom demonstrates the informant's basis of knowledge, or an appropriate level of verification. Accordingly, police must take some time to corroborate an anonymous tip for it to lead to probable cause. Requiring probable cause for a search or arrest warrant has two aims. First, it protects people from unreasonable searches and seizures. And second, it promotes police transparency and accountability, as law enforcement officials must explain to a magistrate why they want to search or arrest someone. Probable cause is not a legal concept frozen in time, as it has proven to be flexible and has been recast throughout our history to ensure that its aims are achieved.
Okay. So now that we have kind of an understanding of the Fourth Amendment and how and what they can get away with in the affidavit, it's a factual document. It can't be misleading whatsoever. But in order for it to lead to a search warrant, it does have to contain probable cause, and that's the part that's up to the judge. But the information that you're providing to the magistrate is going to have to be factual to the best of your knowledge at the time. We're going to take a look at this is a case of Eden Prairie. This is the detective I was referring to. They found out he was lying on all his probable cause affidavits and therefore tainting the search warrants, I think for over 30 cases, and they were all overturned. And we're talking about some heavy duty charges and some really bad people. I'm sure we wouldn't know, and we can't say for fact now. That's most likely why they were released. Let's take a look.
Evening to you and Amy. The Hennepin County Attorney's Office telling us today it's their understanding that the city of Eden Prairie is moving to fire this detective, though we got no official comment on Friday from City Hall. What I can tell you, he is a one-time police officer of the year in this city back in 2011, a man awarded for his work investigating drug overdose deaths, I should say, all across this metro. Yet tonight, his work, his job might not be the most important issue he's facing. He might be looking at criminal charges.
We would not trust him as a witness for any further prosecution. I believe they are in the process of terminating him.
It was a bombshell announcement Friday morning from the Hennepin County Attorney's Office. An Eden Prairie police detective, Travis Seraphin, allegedly lied under oath and falsified a search warrant. His actions costing prosecutors more than 30 cases, all of them dismissed. Authorities explaining his work, now tainted.
Detective Seraphin's behavior here was wrong and inexcusable.
The initial case centers on this man, Timothy Holmes, now serving a 6-year prison sentence for selling drugs as part of a plea deal he made with prosecutors. Holmes was initially charged with third-degree murder in an overdose death of an Eden Prairie woman in June of last year. Investigators had a search warrant for the apartment where Holmes lived on 4th Avenue South in Minneapolis. Inside, they found heroin and fentanyl, according to the criminal complaint. More turned up in his vehicle, but a judge never granted them permission to search the automobile. When pressed on the issue, Detective Seraphin allegedly produced a bogus addition to the original search warrant and then apparently lied about a clerical error in a subsequent court hearing. Hennepin County Judge Fred Karasoff was suspicious and reached out to the Eden Prairie Police Department. The review leaving prosecutors no choice but to dismiss all the cases. Detective Seraphin was the primary investigator in the months since he submitted that bogus paperwork. And that includes a likely release soon of Timothy Holmes. One of Holmes' loved ones asked us to conceal her identity, talking about the stunning revelations.
He didn't deserve it.
Wow. Can you believe that? So, I mean, the guy, by taking a plea deal, he's basically admitting guilt, you know? Some might say people do that, you know, just to get a strategic sentence, you know, something a little less. Gang stalking. I've heard that before. I've heard that term. Yeah, Summer Wells, that's a man. That poor girl. You can just tell she had it rough from the start. Okay, so this next one, it's basically the latest developments in the Breonna Taylor case, regardless of political affiliation. This is not a political channel, so do your best to keep that holstered. Let's focus on um, the subject or the topic at hand here and how it relates, because I think it's extremely important. Listen to the details on how he's explaining all the technicalities and how it got a lot of people in trouble, which is why um, what I'm trying to convince you is that there's more facts that lie in the Ron Logan affidavit than what lie in Kagan Klein's interview transcript. Um, and we'll go into that more in detail. I don't want to get too sidetracked. We'll kind of let that come up naturally, which it will here before too long. But let's take a look at this press conference. This is in regards to some of the law enforcement personnel who were working the case and some charges that were filed against them.
Let's go out to the DOJ, where a former Louisville, Kentucky police officer was arrested by the FBI today on charges of civil rights violations in connection with the 2020 raid on Breonna Taylor's apartment.
The Justice Department has charged 4 current and former Louisville Metro Police Department officers with federal crimes related to Ms. Taylor's death. Those alleged crimes include civil rights offenses, unlawful conspiracies, unconstitutional use of force, and obstruction offenses. The 4 defendants were charged through 2 separate indictments and 1 information. I'm going to begin today by discussing the civil rights offenses that stem from the falsification of a search warrant. We allege that these offenses resulted in Ms. Taylor's death. These charges focus on the conduct of the Louisville Metro Police Department's Place-Based Investigations Unit. In the first indictment filed today, we allege that in early 2020, that unit was investigating suspected drug trafficking in the West End of Louisville. On March 12, 2020, officers from that unit sought 5 search warrants they claimed were related to the suspected drug trafficking. 4 of those warrants targeted properties in the West End where that activity was allegedly occurring. A 5th search warrant was for Breonna Taylor's home, which was approximately 10 miles away from the West End. The federal charges announced today allege that members of the Place-Based Investigations Unit falsified the affidavit used to obtain the search warrant of Ms. Taylor's home, that this act violated federal civil rights laws, and that those violations resulted in Ms. Taylor's death. Specifically, we allege that Ms. Taylor's Fourth Amendment rights were violated when defendants Joshua Janes, Kyle Meany, and Kelly Goodlatte sought a warrant to search Ms. Taylor's home knowing that the officers lacked probable cause for the search. We allege that the defendants knew the affidavit in support of that warrant contained false and misleading information and that it omitted material information. Among other things, the affidavit falsely claimed that officers had verified that the target of the alleged drug trafficking operation had received packages at Ms. Taylor's address. In fact, defendants Janes and Goodlatte knew that was not true. We further allege that defendants Janes and Meany knew the search warrant would be carried out by armed LMPD officers and that conducting that search could create a dangerous situation for anyone who happened to be in Ms. Taylor's home. As outlined in the charging documents, the officers who ultimately carried out the search at Ms. Taylor's apartment were not involved in the drafting of the warrant and were unaware of the false and misleading statements it contained. When those officers executed the search warrant, Ms. Taylor was at home with another person who was in lawful possession of a handgun. When officers broke down the door to Ms. Taylor's apartment, that person, believing that intruders were breaking in, immediately fired 1 shot, hitting the first officer at the door. 2 officers immediately fired a total of 22 shots into the apartment. One of those shots hit Ms. Taylor in the chest and killed her. We allege that the defendants knew their actions in falsifying the affidavit could create a dangerous situation and we allege these unlawful acts resulted in Ms. Taylor's death. The charges announced today also allege that the officers responsible for falsifying the affidavit that led to the search took steps to cover up their unlawful conduct after Ms. Taylor was killed. We allege that defendants Janes and Goodlett conspired to knowingly falsify an investigative document that was created after Ms. Taylor's death. We also allege that they conspired to mislead federal, state, and local authorities who were investigating the incident. For example, we allege that in May 2020, those two defendants met in a garage where they agreed to tell investigators a false story. This indictment separately alleges that defendant Meany lied to the FBI during its investigation of this matter. Another indictment filed today alleges that after Ms. Taylor was shot, another LMPD officer, defendant Brett Hankison, moved from the doorway to the side of her apartment and fired 10 more shots through a window and a sliding glass door, both of which were covered with blinds and curtains. Defendant Hankison has been charged with 2 civil rights offenses, alleging that he willfully used unconstitutionally excessive force
so crazy.
while acting in his official capacity as an officer.
Jesus. Yeah, I mean, I'm sure even other law enforcement couldn't condone those actions, which I'm sure they don't. That's a good question, Matt. Matt's asked, has it ever been discussed how police missed all the CSAM on Klein raid in February 2017? Or was it all on the missing iPhone? No, I think that's when they captured all the information. Because we look at that probable cause affidavit when they did the search warrant back on the 25th is when they originally found all those devices. Yeah, that case is awful. But if you paid attention, these guys got in big trouble for falsifying information. So I've heard of, even myself, I thought maybe, hey, well, they can kind of mislead somewhat, right? In an arrest, in a probable cause, or, while trying to get a search warrant. How else am I going to further my investigation if I can't get the answers that you need without going where I need you to give me permission to go type of deal. It's like a catch-22. So it's almost like an acceptance of, okay, most of this information might be misleading and half truths or maybe not personally verified, but at least it's explained on where the information is coming from. And to the best of their knowledge, it is accurate information. And then it's up to the judge to say, okay, I see probable cause. Yeah, that's correct, Anne. Something that I hate even more is when people use tragedy like this for political gain and for political purposes. And then you forget about Breonna. Okay. Now the next one here. Let's see. I pulled this off of a law website. It was titled Liability for False Affidavits from FLETC. Oh, no, I'm sorry. That's another document here. Yeah, let's read that first. Okay, so that's where I recovered this. I'm not going to read the whole thing. It's very long, but you can actually, they give you a nice little spot where you can download it. So I recommend downloading this and reading it. It's about 4 pages. But we're just going to read a couple paragraphs that I highlighted. All right, civil liability for false affidavits. Brian R. Lemons, Acting Division Chief. All right. Quotations. Reasonable minds frequently may differ on the question whether a particular affidavit establishes probable cause. And great deference is to be given to magistrates' determination of the matter generally. A law enforcement officer is not expected to question a probable cause determination made by a magistrate judge. Instead, magistrates' determination of probable cause is to be given considerable weight and should be overruled only when the supporting affidavit, read as a whole in a realistic and common sense manner, does not allege specific facts and circumstances from which the magistrate would reasonably conclude that the items sought to be seized are associated with the crime and located in the place indicated. So I guess making sure everything matches up, all the information needs to be verified. And I don't think that happens very often. Not recklessly disregarded the truth. The purpose of this article is to discuss the liability that a law enforcement officer may incur in such a situation. Part 1 of the article discusses the mechanisms through which civil rights lawsuits are generally brought against state and federal law enforcement officers. Part 2 generally discusses the concepts of qualified immunity. So let me go to the next one here. Oh, here it is. Liability for false affidavits. Before an arrest warrant is issued, the Fourth Amendment requires a truthful, factual showing in the affidavit used to establish probable cause. Because the Constitution prohibits an officer from making perjurious or recklessly false statements in support of a warrant. Okay, so I found that interesting, and it led me directly here. Because really it made me start to question how different those rules are for interrogating a subject or person of interest. So let's take a look here. And I think this is from Valiente Law. It's titled, Can Police Lie to Me During an Interrogation Process? And the link, like I said, all the links can be found in the description. This one's pretty interesting.
People without experience with the criminal justice system often are amazed by the answer to this question, but yes, the police can lie to you during an interrogation. There's limits to it, meaning they can't fabricate evidence to make you think that something else did happen, for example, but they can absolutely tell you, well, your person that was arrested with you, they already confessed and said you did it, so you may as well just come clean and we'll try to help you out later with the prosecutor. They can tell you that, oh, you know, your wife or your mother, I spoke to her and she's just so torn up about this, she's so embarrassed and ashamed, she just wants you to resolve this as quickly as possible, just come clean. Yes, the police are allowed to lie to you, and that is something to keep in mind if you should ever happen to be in an interrogation room or being interrogated by the police, is that what they're telling you, for better or for worse, it may be a lie. Knowing that the police can lie to you is why, first of all, even without a lawyer, you probably shouldn't talk to them. But two, if you do decide to speak with them, you absolutely want to invoke that other part of your Miranda rights, which is if you want an attorney, you have the right to have an attorney present. Call your attorney and get them in there, because police act very differently when they know that there's someone who knows the limits of what they can do. If the police overstep their bounds on what they can tell you, meaning they're allowed to tell you that your co-defendant confessed, for example, or that they're allowed to tell you, you know, hey, we found the gun and we got fingerprints off of it, all right? And they match your fingerprints.
Right? Doesn't that stuff sound a lot like the Keegan Klein's interview? A lot of stuff like that, you know?
They're allowed to say that to you. Now, if they then come into the room with a fingerprint card and say, here it is, here's the proof, here's a fingerprint we took off of the gun, that is when they cross the line. That's what, they're not allowed to do that. If they do something like that, we can absolutely file a motion. And in that example, obviously it's a very simple example, but yes, I mean, it's a situation where the case might not necessarily be dismissed, but we should be able to file the appropriate motion to suppress whatever statement you may have made and keep them from using that against you, which in a lot of cases will result in a dismissal.
Oh, hold on. Put that back up there. I thought I saw the number. Anyway, link is in the description. Thanks for that helpful video. All right, because of time, we're probably going to catch up on chat here and then jump right in to the affidavit and the topic of today's discussion. Hey, what's up, Shay? Cops lie a lot, and it seems like there are penalties if they get caught. Some do, some don't. Question is, do state laws vary? Are they translatable with what laws the FBI has to abide by? Which should just be the Constitution, but we know we need that kind of explained in detail. Yeah, Man Vroom says, bottom line is you should always clam up and ask for an attorney. And there's a part of this affidavit that made me understand why. So they asked Ron Logan a question, and we'll get to it. I think it was something along the lines are, well, we're only going to get a search warrant if we find evidence that leads us, back to you or whatever. That's the only way we'll be able to get a search warrant. And they asked him, do you think we'll find anything that leads back to you? And they put in quotation marks, Ron Logan saying, I don't think so. Or something, like something stupid, like an innocent person would say, like, well, completely unaware that there's going to be a million eyes, dissecting that one little phrase or, those few words that he's being quoted there. And having those words sent to a judge and saying, hey, look, this is part of the reason why he's, I think this guy's guilty because of something he said. But if you listen to your attorney and didn't say anything, they would never have that. We wouldn't even be talking about it or using it as a perfect example. Good point, Rockaway. Says prosecutors love to withhold exculpatory information. And it's funny, withholding information is kind of the same thing as putting it's almost the same as falsifying information. So if you're giving a detail, you have to kind of explain exactly where it came from. And if you say, I verified it, that has to be true. That's right, Tina. That's why we have the Constitution. Hey, yeah, it's good to see you, Shay. But it is possible. Okay, I think what we're going to do is I'm going to show a quick video. I think this is from Fox News. Local. I think it's local there in Indiana. It's kind of when the news broke from the Murder Sheet podcast. I think, the local media knew to jump on it after what happened with the release of the transcript from Kagan Klein's interview. So I think we'll start there, and it should be a good segue right in there. And then we can even talk to people who still consider Ron Logan, to be a person of interest. And is that because of the affidavit? And do you think that because they kind of fibbed or stretched the truth a little bit, or were misleading with the information? Or is it that we're not understanding the factual information quite right? Or is Special Agent Nikkole Robertson, is she just, presenting the information in a biased way to somebody that she really suspects, and really is trying to say, hey, look, judge, these are the real reasons why, I really suspect this person, and I think there's probable cause. And if we can just get inside there and do a thorough search, we're going to find, she's talking about finding fibers. She's talking about finding blood and hair. She has all these things that she's confident that she's going to find, and she's going to cross all those boxes. So remember, they didn't cross not one of those boxes. But another question is, did they cross all the boxes but lie in the affidavit so they couldn't do anything about it? Maybe all that information got thrown out. I've never heard of that. I'm just wondering, what if? So I think that's why it's important that if law enforcement, they must be honest, when they're doing an affidavit. To me, that's where all the risk is. Imagine having some really valuable information that they found in one of the search warrants, but because they violated somebody's rights, they had to throw that evidence out. I wonder if something like that could possibly be going on, but who knows? Just a thought. Okay, before I play this little Ron Logan bridge guy comparison, we should do the comparison before we dive into the information. Because it's pretty clear what's going on here, in my opinion. But I think there's still some people that aren't sure. It's very misleading. And it can be confusing. So the best way to do it, let's look at the evidence. Let's compare them.
Down the hill. 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 Down the hill.
All right, that was 1 full minute of Ron Logan not looking like Bridge Guy and not sounding like him. Now, was he involved? I don't know. But just looking at this, it's pretty clear. And if Ron Logan's about 6'1", to me, that says that the Bridge Guy is about 5'9", 5'10". Mindy says same positions. Wow. Morgan Lee Fay says, no, I just don't have it that Ron Logan was involved. Well, we're going to find out. I just thought we should start with the comparison because the information makes it seem as if he's extremely involved if you're not reading between the lines. I mean, look at him. He's wearing a blue jacket. He's wearing blue jeans. Look at that hat. It has a dent in the top. And his hands are in his pocket. I mean, God forbid his fingers are cold. So as far as him being involved, I can't say yes or no. But what I can say is, unless my eyes are deceiving me, these are not the same people. The only way these are the same people is that image that we're seeing from Libby's phone is just so completely blurred and so completely misleading that his entire face is covered. And Ron Logan's hiding somewhere behind some type of face covering. Then, I mean, it's just not possible. I mean, look at the torso, the length. So his hand is in his pocket here. His hand is in his pocket here. And there's just so much more space here. He's just so much more taller. In my opinion. That seems to help people when you say that at the end. All right. I think I put that up there. Hopefully I was clear. I'm not sure. I could be wrong. All right, let's get right into it. So there she is, Nikkole Robertson. I mean, I don't know who it sounds like, but the closest one that I've heard was Kagan Klein. I mean, it sounds just like him. Yeah, just a search warrant. No arrest warrant. Yeah, and they found absolutely nothing. That's a good point, Honeybee. Everyone sees these comparisons differently. That is 100% correct. And that's why you got to say, in my opinion. Well, sometimes I see a mustache or something. It's either like a part of the covering that just happens to be shining. It's so misleading because every frame, like I'll see an old person and then I'll see a young person. Then I'll see somebody that may even look like a female or maybe even a really young person. Or sometimes even like a person with like a beard. So, I mean, it's really hard. And I'm pretty sure that's why they say they want you to look at the mannerisms and the way the person walks. They're like, stop talking about the face. Can't see shit. Look at the way the person walks. So I want to make that part clear before we start going into pareidolia land. But don't worry, I have a condo there. All right, let's get started. Nikkole Robertson swears or affirms that she believes and has good cause to believe evidence of a homicide is located in the residence of Ronald Logan, situated in the county of Carroll, in said state, which is described as a white 2-story single-family dwelling situated in the county of Carroll. Hold on. Nikkole Robertson. I, Nikkole Robertson, am a special agent with the Federal Bureau of Investigation and have been employed as such for 12 years. Prior to her employment as an FBI agent, Nikkole Robertson was employed as a Sauk Village, Illinois police officer for approximately 6 years. Nikkole Robertson is assigned to the Maryville Resident Agency and currently participates in the investigation of all violent crimes. So I wonder what that means. Every time a certain type of crime comes, she touches it, I'm wondering, or she'll get a copy of the file or the case file. Get an opportunity to have her, I don't know, maybe write up a report, give what she thinks is going on. Well, she says and remember, these got to be factual. And that's kind of what I was trying to prove at the beginning of the video. And I'm not convinced yet. I don't know. But from what I can see, she would be taking a very huge risk to her career if she was misleading. And if she was misleading, I think at that point we'd have to ask why. So, I mean, that's a whole, and there's just nothing there that would suggest she has motivation to lie in this document. This is not like an interview. She can't say, oh, well, I found fingerprints and Ron Logan's blood was all over here, and this and that. It's all factual information that's been backed up in some way or the other. So on February 13th, 2017 at approximately 1 p.m. So 1 p.m. we've argued and we discussed 1:30, 1:45. Approximately 1 p.m. is not 1:30. If anything, that would be anywhere between 12:45 or 1:15, right? So we'll just assume that the girls were actually dropped off closer to 1 p.m. Hereafter referred to as Abby and Libby were taken to the Monon High Bridge Trail located in Delphi, Indiana. Abby and Libby were walking the trail in the area of County Road 300 North and 575 West. .575 West. I wonder where that is. Latitude 40 degrees, 35 minutes, 21.4 seconds. 86 degrees, 38 minutes, 23.3 seconds at approximately 2:13. So this is where I wanted to kind of stop right here. We're going to focus very closely on this. Like I said, we're going to do kind of a dive into all this information. We're going to break it down. Yeah, and apparently you can't even use that video to eliminate Ron Logan. I mean, at that point, it's kind of... All right here. So at approximately 2:13 p.m., which was the time of last contact with Libby and Abby by cellular device. So let's focus in on... So what that means to me is the video from Libby's phone must have been, like a snap video. I based that on the words contact and cellular device. So how else are you going to go ahead and have contact at 2:13 via cellular device, and at the exact same time prove that that's when the video was taken. So, I mean, that's a dead giveaway, right? So let me check the comments on that one. Sorry, I'm skipping all the way down. So what do you guys think about that? So at approximately 2:13 p.m., which was the time of the last contact by cellular device, I mean, that has to be, to me, that's a Snapchat right there. They were to be picked up by a family member at 3 p.m., and the victims never met with the family member. So to me, that lines up kind of with Derek German. So he must have pulled up exactly at 3 p.m. He parked there and he's trying to make a phone call and nobody's picking up. Approximately 5:30 p.m. was the last successful ping of the cellular phone by AT&T. Okay, now if the phone was pinging at 5:30, we know it was on until at least 5:30 p.m. Do you guys agree with that? Because from my understanding, you can't locate it when the phone's off. You're not going to be able to ping. So to me, if the girls did go through the creek, to me that says that the phone did not shut off because of water damage. Because if it's pinging at 5:30, they would have already been, through the water by then. Hey, what's up, Mandy? Yeah, he did a lot that day, Teresa. So it's either that he completely pre-planned all of this and maybe that's part of the reason why he went to the dump. I don't know. Maybe it's part of the staging. No, that means that nobody touched her phone. Her phone was on until 5:30 at least. It says right here, approximately 5:30 p.m. was the last successful ping of the cellular phone by AT&T. You can't get a ping when the phone is turned off. So it was on till at least 5:30. So that means that the phone wasn't destroyed by any water damage. And it laid there until about 5:30 and and must have just died, or maybe was destroyed. I'm not sure. And we know that, the killer most likely wasn't hanging around till 5:30. So if they got a successful ping in that location and it was the last one, that tells us, they most likely did get the video directly from that phone. Oh, we're going to get into that, and there's going to be stuff that backs up a theory that I'm going to go into here in a minute. And I want to get your guys' opinion about it. Okay, let's continue on here because of time. Abby and Libby were located deceased on February 14th, 2017 at approximately 2:17 p.m. at the above listed latitude and longitude, having been victims of murder in accordance with Indiana Code. Okay, suspect has been developed of a white male wearing a blue jacket with a heavy physical build, wearing a cap and blue jeans. All right, it doesn't say possible, hair or certain type. It just says a cap. I don't think that's up for too much debate, I mean, a cap, that's like a baseball cap. Baseball cap, wearing a cap and blue jeans. The development of the suspect was made by a 43-second video taken on Liberty German's phone, where the suspect follows the victims as they are walking on the High Bridge Trail. Okay, so right here, the development of a suspect was made by this video. So are they taking into consideration how misleading this video could be? Especially with height and weight? Did they do the necessary, I guess, homework? I mean, to me, that should have been something that should have been very specific in the beginning. Near the end of the video, the suspect speaks to the victim saying, "Down the hill." It sounds as though he is directing the victims to leave the trail they were on and enter the wooded area below. No person has come forward and identified himself as a person who met the victims and made the statement in Liberty German's video. Therefore, it is believed that person in Liberty's video participated in the killings. Images of the suspect have been broadcast on the news media since February 15th, 2017, as a person of interest. Libby and Abby are presumed to have made contact with the unknown male at approximately 2:13 p.m. Okay, so how do you make contact with the suspect and also make your last contact that includes a video? How is all that included together? It's a Snapchat. So she posted a video. That was her last communication. And it was also the video that we're watching when we see that guy walk on the bridge, in my opinion. Okay, so we have a recorded video and contact taking place at the 2:13 p.m. mark. On February 14th, 2017, at approximately 12:17 p.m., the victims, Libby and Abby, were found dead with wounds caused by a redacted weapon on the property owned by Ronald Logan. A large amount of blood was lost by the victims at the crime scene. Because of the nature of the victim's wounds, it is nearly certain the perpetrator of the crime would have gotten blood on his person or clothing. The location of the crime scene is approximately 1,400 feet from Logan's residence. Logan is a 77-year-old male. Logan's physical build is consistent with that of the male suspect videoed by Libby on the Monon High Bridge Trail. Logan owns farmland, cares for large farm animals. Logan appears to be in good physical condition. Logan has been interviewed several times. His voice is not inconsistent with that of the person in the video. All right, so let me stop here before I get too far. Let's see what's going on in the chat here. Yeah, that's very possible. Maybe put it all in kind of like a pile or a bundle and just kind of went running and tried to throw it out there. I could see that. Yeah, it had to have been an extremely small window. Yeah, I think it breaks it into increments, but I actually read you can do like up to a 60-second video. Yeah, I looked that up today right before the live, before I talked about it. But yeah, it says 60 seconds. Now, 2017, who knows? So maybe we could rephrase that. Snapchat or something similar. Now, I don't know, does what's the other one? Instagram? Can you send videos on that? Or maybe even just post it, like post your video. I know you can post like stuff to like Facebook or from Facebook or, you know. Or maybe she sent that video to one of her friends, like, hey, like, check this out. Check out this creeper. But I think it was something, I'm thinking something more live. You know, how did it send? Like, she wouldn't have had time to send it and prepare it. Really, only Snapchat, I think, is the only way you're going to be able to do that, you know, where you're doing it live. And then regardless of what you do next, eventually it's just going to go off and then send, you know. All right. Let's keep moving on. All right. It was also discovered that the redacted of one of the victims was missing from the crime scene while the rest of their clothing was recovered. It also appeared the girls' bodies were moved and staged. Based upon my training and experience, it is common for perpetrators of this type of crime to take a souvenir or in some fashion memorialize the crime scene, whether by photos or electronic or digital methods that are then downloaded onto computers, storage devices, tablets, phones, iPad devices, and other electronic devices that store digital data for later viewing, scanning, or copying. So you have an FBI agent here kind of insinuating that, in her opinion, they may have taken maybe a photograph or video. I mean, this case is extremely complex. I think this case was even complex to maybe even to the FBI. Abby and Libby had no visible signs of a struggle or fight. During the processing of the crime scene, investigators located unknown fibers and unidentified hairs, which may later be used for comparison of similar fibers or hairs. So fibers and hairs end up on later on in a list of things that they plan to find or expected to find in the search warrant. So let's take a look. Logan owns numerous weapons, including handguns and knives that were observed by law enforcement during an execution of a search warrant that took place at his home March 6, 2017. Logan's home was searched as a result of a probation violation. Now, during this probation violation, they were only able to search his primary residence, just his home, none of the garages or his sheds or anything like his barn. And that's kind of what this probable cause affidavit was trying to attempt, was get the ability to go search the rest of the property. The search was limited to the discovery of firearms and included only his main residence. On February 14th, 2017, at approximately 9:20 a.m., Logan contacted his cousin, name redacted. Logan asked his cousin to tell the police that he came to Logan's home between 2 p.m. and 2:30 p.m. on February 13th, 2017 to pick Logan up. So the notes here, in my opinion, if Logan could quickly prove that he was not around when the girls went missing, they would have no reason to check why he was out violating his probation that day. So if he could quickly just, hey, I need you to say this, even though he may have even been home or just getting ready to leave, He knew if he can just get somebody to take him out of the equation, they would just be like, oh, well, you have an alibi, because he's assuming it's like if they think it's Ron Logan, it's got to be some type of random killing, right? It can't be planned out. Or so if he's like, if they're suspecting me of a random killing, that means I just need to make myself busy between 2 and 2:30. And everybody in Delphi knows by 6 o'clock that day that there's 2 missing girls that went missing from 2 and 2:30. So that's common knowledge at that point. Logan further told his cousin to say that his cousin drove Logan to an aquarium store in Lafayette, Indiana. Logan told his cousin to say they returned home to Logan's house between 5 p.m. and 5:30, which was most likely true, except that he probably was driving drunk. On February 14th, 2017, while requesting consent to search Logan's property, the law enforcement officer advised Logan that law enforcement would not search his home unless evidence led law enforcement to Logan's house. In that meeting, Logan told the law enforcement officer that he did not think evidence would lead them to that, but said, I don't know. So they felt the need to include that in this affidavit, which is a good reason why, take your lawyer's advice and don't say anything. He literally said, I don't know. Like, I don't know what you're going to find. Like, if somebody was framing me, you might, I don't know. How am I supposed to know? Like, what kind of question is that? Like, to me, that's a sarcastic answer. I don't know. Like, why would I know anything about anything that's going on? I just live here. A receipt from an aquarium world in Lafayette dated February 13th, 2017, with a checkout time of 5:21 p.m. was found in Logan's home on March 6th. During a probation violation search, Logan resides approximately 22 miles from the store, would take approximately 30 minutes. Okay, so if he's there 5:21, 30 minutes, there and back, that's 1 hour. So that puts him at 4:21, right? Assume he spent 21 minutes in the store, maybe less, puts him at the store and shopping, put at about 4 o'clock. So that means that he would have had to commit the murder, clean up a crime scene, get himself prepared and out by 4 so that he can make it to the aquarium. So if you can see, the pocket of time just keeps shrinking and shrinking. On March 6, 2017, during an interview with law enforcement, Logan said he was picked up by his cousin around 3 p.m. and taken straight to the aquarium store in Lafayette. In the March 6, 2017 interview, Logan said after he was done at the aquarium store, he was driven straight home. These statements were found to be factually false and intentionally designed to deceive law enforcement. On March 7th, 2017, his cousin was interviewed by law enforcement, told law enforcement that he was with Logan on Monday, February 13th, 2017, that he did take him to the aquarium in Lafayette. He was also interviewed by another law enforcement officer regarding the trip to the aquarium. His cousin told law enforcement that he had lied when he was interviewed by law enforcement. So I wonder if he felt guilty. At Logan's request, explained that Logan had never asked him to lie for him in the past. His cousin knows that Logan has driven his vehicle while on probation and was prohibited from doing so. Also said that Logan did not ask him to lie for Logan when Logan drove to the transfer station earlier in the day. So that kind of goes back to what I was saying. Let me read my notes here. I think Ron thought he was being accused of a random act. Ron knew they were dropped off at 1:30 p.m. In his mind, maybe he thought it really wouldn't matter what he was doing prior. Does that make sense? So if you're just trying to come up with something quick that eliminates you from even being involved, like, hey, I need you to say this, this, and that. Oh, and then also I need you to say this, this, and that because they're going to find out I was out drinking. Yeah, the territorial local killer theory. Yeah, that one makes a lot of sense. The only thing is it would most likely take out, the most important part, which is the Anthony Shots profile. And it's almost the same thing that eliminates Ron Logan. Unless Ron Logan seen something and, knew the killer, was like, damn, I got to get out of here. I think they did, but the phone was recently reset, Lisa, and I think that wasn't added back on, which in itself is another strange thing. In 20 years, we will find out who did it. That's awful. Yep. FISA is different, though. That involves like foreigners, and then they try to attach like Americans in there. The water wasn't extra high that day. It's my understanding. But I could be wrong. Hey, what's up, Jim? That's the first time I'm hearing that, Shay. Sorry. Yeah, at least 2. I think you need 2 to get, because I'm starting to think that the crime happened before they crossed the creek and they were carried over there. That's where the reason they're on the other side of that creek, I think, is because they were hidden over there. So I don't think that Ron Logan would hide people on his property. You know what I mean? He would most likely, if it happened on his property, he would have crossed the creek and put him maybe under the bridge, or something away from him, or maybe over on somebody else's property. Who's KG? I don't know who that is. Perfection. Yeah, you got it right, John. The person or persons who committed this crime planned it to total perfection, unless it was the luckiest killer known to man that no one has ever seen, heard, or before, or seen since. I mean, that's 100% true, and that's kind of the conundrum. That's correct, Ann, but it will not ping if the phone is shut off. So we know it was on at least till 5:30 p.m. All right, let's keep going here. So on March 12th, 2017, his cousin explained in an interview to law enforcement that Logan called him on the morning of February 14th and asked him to provide the alibi for Logan's drive to the aquarium in Lafayette. This phone call was made prior to law enforcement's discovery of Libby and Abby's deceased bodies. Based on investigators' experience, it is reasonable to believe that the creation of an alibi prior to the discovery of a crime indicates culpability or knowledge of the crime. The notes I put here were before the discovery, yes, but not before the girls were announced missing, along with specific times mentioned, the 2 p.m. and 3 p.m. This would have become common information way before the morning of 2/14. I believe Ron Logan had to provide access to multiple search parties. And I'm sure at one point he was just kind of looking around, maybe wandering around, maybe showing people around like, hey, you can walk all the way back here, or there's a path here. So his phone's going to be pinging all over that place. The cousin said he thought the photograph of the male that was released by the media of the man on the bridge looked like Logan. And we already compared. See, I don't understand. Like, really? Learned that Logan had driven on February 13th, 2017 to the transfer station in Delphi, Indiana to drop off trash. Video from the transfer station shows Logan driving his white Ford pickup truck between 11:27 a.m. and 11:32 a.m. The video from the transfer station appears to be off by 26 minutes, putting Logan at the transfer station from, see, it doesn't tell you when he leaves. 11:53, so we'll say 12. So if he's at the transfer station up until 12, I mean, that would have put him, what, back home by 12:15, 12:30? Logan did not ask his cousin to provide an alibi for his drive to the transfer station on the 13th, only asked to provide an alibi for a trip that would have occurred at the time of the apparent abduction of Libby and Abby. To me, in his mind, it's like, okay, they suspect me of a random crime. Like, girls are walking near my home and they think I just came and like kidnapped them and killed them. That's what they're accusing me of. That's what they're going to accuse me of. I need you, I know that they disappeared apparently around 1:30. So I need you to take me out of the equation before they find out I was violating my probation and lock me up. Okay. So there was couple of other parts I want to go before we get out of here. Okay. So there was an interview with the witness said Logan carried a gun everywhere he went and knew that Logan would carry a gun in a fanny pack. Described Logan's fanny pack as one made out of a nicer material. So it's almost like this person was assuming that what she was seeing was a fanny pack, which we've all taken a close look. It maybe, we can't tell. So it's almost like she's using her assumptions along with like confirmation bias, maybe in coercion with this agent. I don't know. That's what it sounds like to me. Like it's almost like they're, kind of coaching them or leaning them. Like, why even talk about a fanny pack? Oh, wait, there's a brown thing on the suspects that appears to be a fanny pack, but when you really look at it closely, no. Honestly, it looks more like a holster, or even what Kim Riley said, like a shirt sleeve, like corner of a pocket, or a hoodie being pushed down, something like that. Recently, I was looking into leather cigarette holders. Have you seen those before? So you put your cigarettes in it, and it kind of looks like a holster, and it has a top, and it latches, and then it even has a pocket for a lighter. There might be like some kind of emblem or something kind of imprinted into the leather on the front. But who knows? A call placed using Logan's cell phone produced cell phone tower data that shows Logan's cell phone appears to be in or around his property on February 13th. Well, yeah. At 2:09 p.m., although his exact location cannot be confirmed, the tower data shows that Logan's cell phone was in the Delphi area, in the area of the Monon High Bridge Trail. An analysis of Logan's cell phone data revealed a text message sent from his phone at 7:56 p.m. on February 13th, 2017. Initial exam of this analysis indicates Logan's phone was likely outside of his residence in the proximity of where Libby and Abby's bodies were located. Okay. So there's a lot of missing information right there. So we know that people first. Oh, thanks, Jerry, for the super chat. Always thought-provoking content. Thank you. Okay, so we know that at 6 p.m., you had people like Pat Brown, I think Kelsey German and others may have been asking for permission to go search on Ron Logan's property. So 7:56, if that's when they began searching and they stopped searching around 9 p.m., why wouldn't Ron Logan be out in his backyard talking to people, maybe even looking around, telling people, hey, if you go this way, there's a trail, or if you stick this way, you know, it's going to be real rough. So to me, for him to be in and around that area at 7:56, even further away from his home, I mean, that seems normal in that situation. What do you guys think? What's up, Goat? Says FBI beefed up the search warrant affidavit to make Ron Logan seem like a monster and left things out that didn't fit their narrative. Blood does go away. If he did it, evidence would have been found. Do you mean blood doesn't go away? Yeah, I mean, here, I think we're only going to be able to read these next 2 pages, and I think that'll be enough because I want to go into what they were expecting to find in Ron Logan's house, and they didn't find anything. I mean, they seemed sure of it. So when we're talking, what is this, March 11th? I can't remember. It's dated on here. It's somewhere in March 16th or something. That's a lot of time for killers to get rid of evidence, to hide, and I mean, this is a lot of energy focused on somebody that I don't think anything really points at him. That wouldn't necessarily point at anybody that didn't live right there. You know what I mean? Okay, so those are the notes I just read. An analysis of Logan's cell phone data revealed a text message received by his phone at 10:16 p.m. on February 13th. Initial exam of that analysis indicates Logan's phone was likely outside of his residence and in the proximity of where Libby and Abby's bodies were located. My notes here read, once again, we know the search lasted well into the night. Why would Ron be talking to people who are accessing his land? No, or why wouldn't he? Better. Logan met with law enforcement on or about February 17th. While they were on his property, Logan was physically able to get up and down the hill from his home to the crime scene. On March 14th, Logan's former housemate was interviewed, stated resided with Logan from about September 2016 through December of 2016. Was in a sexual relationship with Logan on and off for approximately 3 years during the interview. Said when she first learned of Abby and Libby were missing and then found dead near Logan's home, her initial thought was that Logan was involved. Said in her interview that she feared Logan and even previously told her baby's father if she ever ended up dead, Logan did it. On March 14th, 2017, she explained in her interview that Logan had been violent with her in the past, explained that on July 4th, 2016, while at Logan's home, Logan punched her in the face, knocking her down. She explained that she was drinking, but Logan was completely sober during the incident. Well, might be 2 sides on that one. She also explained that Logan was angry because she disrespected Logan while in Logan's home. On February 13th, 2017, Libby's family began searching the area on the trail where Libby and Abby were initially dropped off, beginning shortly after 3 p.m. Okay, so this lines up with Derek German walking on the trails around 3:11. So they're scheduled to be picked up at 3 p.m. And eventually he's like, well, they're not answering my calls, they're not returning my texts. And around 3:11, he takes to the trails. So even though we don't have a timeline officially from law enforcement, we're seeing a lot of the facts here in this affidavit, which is law enforcement, coincides with the family's timeline, at least up to now. Family and other community members joined the search shortly after. Shortly after, to me, that 4:30, that aligns with what we know or what we heard. Carroll County Sheriff's Office was notified approximately 5:30 p.m. Matches with what we heard also from Becky and Mike in their interviews. They said we started searching around 4:30, and we made the call around 5:30, which seems appropriate to me. You know, they didn't wait too long, in my opinion. Once the search for Libby and Abby began, the one reported, this is important. No one reported seeing any person matching the description of the male on the bridge. Did you guys catch that? Let me read it. I'll read it again a little bit slower. Once the search for Libby and Abby began, no one reported seeing any person matching the description of the male on the bridge. So does that mean they were just going around asking people during the search, like, hey, did you see this person? So when they say once the search for Libby and Abby began, they're kind of blanketing the rest of the statement within that time frame. No one reported seeing any person. So does that mean that they had a description of this man already? Once again, making me think that they had the Snapchat. And they maybe were asking people, hey, have you seen this guy? You know, oh, we were supposed to meet Abby and Libby here. We missed them on the trails. Oh, okay. Did you see this guy here? And they're like, oh no, but I got that same Snapchat. And they might say, well, hold on to it. Don't share that. You know, if you hear anything, let us know. I mean, is that possible? To me, that's how it reads here. Once the search for Libby and Abby began, no one reported seeing any person matching the description of the male on the bridge. Why would they? Nobody knew about it until days after. Now, is this an interview where people who were there from the beginning are saying we never saw anybody during that time frame? I'm not sure about that. A search of the database has revealed 15 tips in which citizens, both known and anonymous, attributed the crime to Logan for various reasons. Now, Logan looks like, now these are my notes here. Logan looks like everyone in Delphi, for one, lives by the bridge, has a shady past. I hope those aren't any of the various reasons that they're referring to, honestly. Based on the above aforementioned facts, Logan was in the area at the time of the crime occurred and that he provided false information. Okay. Yeah, we'll end it there. So we will do the next maybe 10 minutes just hanging out in the chat. And then I got to get out of here. That's a good point. And I think they mentioned that. Is it Gil? Says, "Hey Sleuth, how would you explain the fact that few different people independently identified Ron Logan as being the bridge guy just based on the video before even knowing about the murders?" Well, how would they know about the video before they knew about the murders? I know that one of the witnesses stated she saw a picture and was like, "Oh, well, they're just looking for Ron Logan," and then read the details and was like, "Delph, I don't believe that, honestly." And to put it bluntly, I think that that's bullshit, because there's no way that that first image that they put out, whether she's referring to, I think it was the very first image, it was either put out on the 16th or the 17th, comes from Libby's video. Looks nothing like Ron Logan. There's no way you're looking at that and you're going, "Oh, that's Ron Logan." And then you look down and it just happens to be a murder right next to his house. I'm calling bullshit on that one. In my opinion. Here, let's pull up that video again. I don't know if you guys caught it in the beginning, but we played a comparison. Whenever I'm talking about Ron Logan, I like to play it. I played it before we got into the affidavit so people can remember, like, okay, well, first off, he doesn't look like the guy. That might save you, the mental anguish. Okay, let me pull this up and then I'll share my screen.
Down the hill. 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 Down the hill.
I mean, I'm not 100% positive, but I mean, not to mention, like, Ron doesn't seem to keep his hat folded that much. I mean, who knows if we're even looking at a hat? They call it a cap, but who knows? Yeah, Mandy, pre-trial. I mean, I figure if they're going to make a deal, isn't that the day to do it? To finalize it? So we're going to keep a close eye on that. Sorry. Well, and Vroom, in this affidavit for Ron Logan, it states it was the last contact. It was the same time of the video that was taken on this bridge. So how can both of those things be possible? Also, while being on a cellular device. think it's the pretrial, Teresa, if I'm not mistaken. Snapchat murders. That's really what it is. But it looks like Instagram played a little bit of a part too. He just kept chasing him, kind of kept forcing him further and further and further. Doug Carter makes it seem like they know exactly what happened out there. And that might be the piece of information. You know, they know when it happened, where it happened, how it all played out. They seem, he made me believe that he knows exactly what happened out there. And I think he even said it a few times, like, we know what happened out there. All right, guys. So we're going to hang out another 5 minutes. I'm going to begin closing it out. Thanks for hanging out with me. It was good to catch up with you guys. I know I tried to check in when I had a little bit of time, so I appreciate you guys being cool and hanging out with me today. And we'll do it again real soon. Yes, I did, Diana. Thank you. Thanks, Teresa. Hey, Olivia. Good to see you. Peace out, baby bear. Thanks, Jim. Good to see you. Don't forget to smash that like button. Oh, did I? Let's go back. It's like I don't see it. You want to go and punch it in there again? Welcome, Nadia. Thank you. Thanks, Vanessa. You know, it's always good to see you. B-Heart says, isn't Yellow or Yubo a live streaming app? Yeah, that's a good point. But they didn't seem to know about it until after the fact. If they had this video and it was from Yubo, I think they may have shared that earlier on. But that is a good point. And Yubo is definitely involved. Direct, I don't know if with Keegan, but definitely with the Anthony Shots profile. Later, Mandy. Good to see you. Yeah, that's definitely true. Yeah, and I wonder if they had that video, and maybe it was around 9 or whenever they called off the search. Maybe that's when they received the video. Like, hey, you got to see this. Maybe they thought they were dealing with an abduction. And it seems like they didn't. It seems like law enforcement, if you think somebody's missing and you're convinced that you searched, if they were attacked, you would think there'd be someone right by the bridge. You search there 3, 4, 5 hours and you don't find anything. And you're going, your instinct, like, okay, well, maybe this is an abduction. So maybe you felt the need to move your resources in that direction. Sykes says, just wondering why they didn't search the landfill, or I've never heard of them doing it. Neither have I. I don't know why they would, unless they believe the crime was pre-planned. And for some reason, part of that pre-planning, something that was done in the early morning hours, then around 12 noon was sent to the landfill. So maybe they did, I'm not sure. I always thought if he is guilty, that definitely plays some kind of part. I don't know if I can make that promise. Hey, good to see you, Dave. Yeah, that could be true, Lisa. Maybe they were able to see what he did on video. Trash transfer station. Yeah, I think where you might be getting the landfill confused with the transfer station. All right, guys, I want to thank everybody who showed up, watched me live, participated in the chat. Good to see you. Anybody watching the replay, salute, and I'll see you again very soon.